Good afternoon, everybody. Thank you for attending today's session on guardianship. Just a couple of reminders before we get started. Please keep your cameras and microphones off to prevent any distractions. If you have questions, please type them in the chat box and I will relay them to our presenter as we go along. And lastly, if you need a certificate of completion, please email Stacey at the end of today's presentation. So with that, I will introduce our presenter, Vicki Peterson, on guardianship.
Okay, hello everybody. Can everybody hear me? If not, type it in the chat and we'll get that fixed. But my name is Vicki Peterson. I'm a family consultant for Family Voices of North Dakota. I also do care coordination for the Pediatric Mental Health Care Access Program. I have been working for Family Voices for 20 years, and I have two sons, one in Washington and a son here at home who's Aaron. He's 21. He has autism with an intellectual disability and chronic health conditions. So I was asked today to go over guardianship processes. So my history with guardianship, of course, is lived experience. I am a full guardian for my son, Aaron, but I've also helped people go through the process of guardianship, learning about it, helping them find resources as well for a good 15 years. I'm also a lobbyist. So there was some legislation this year too that we participate in for guardianship. So guardianship is the legal process when a person can no longer make or communicate safe or sound decisions about themselves or their property. Typically, when we're talking about property that someone is going to take over, it's called a conservatorship. And I don't go too much into that, but if anybody had specific questions on conservatorship, they could definitely contact me and I could get them in touch with resources for that. So establishing a guardianship may result in considerable loss of right for the individual. So it's really important to think about guardianship just not at a spur of the moment, take time to plan it out, and really take into consideration of what a guardianship may do or may not do. And then also through this presentation, we'll talk about alternatives to guardianship as well. The appointment of a guardian is done by a court order after a hearing. The hearing is to determine whether the individual lacks ability to make responsible decisions concerning legal affairs, medical treatments, financial affairs, housing, or concerns over safety or health. Courts will always look for the least restrictive for that individual, and typically guardianships may be either limited, which is partial, or non-limited for full. Typically during this time, I usually get a question, especially when I'm conducting some workshop or training for, or just talking to families, do you need an attorney for a guardianship? Yes and no. Yes, you might really consider that it's important to have an attorney because there's a lot of legal things that go on. There's a lot of legal language. The process is kind of long or can be long, just depending on what type of guardianship you're looking for. But is it mandatory that you have an attorney? And it is not. You will see as we go through the slides, there is a website you can go on, which does tell you the process of doing guardianship on your own. Wouldn't recommend it unless you have a pretty good law background. Okay. So what is the legislative intent of guardianship? So it is the intent that the legislator protect the liberty and autonomy of people of the state and to enable them to exercise their rights under the law to the maximum extent consistent with the capacity of each person. So typically when we're talking this, we might be talking about people who are aged, people with disabilities. We could also be talking about some other things of maybe they were traumatic brain injury, where you might need some type of guardianship, maybe not all. So there's a large group of people that you'd be thinking about. The legislator recognizes that people with incapacities have unique abilities and needs, and that some people with incapacities cannot exercise their rights or provide their basic needs without the help of a guardian. Remember, we will talk about alternatives to that as well. However, their liberty and autonomy should be restricted through guardianship process only to the minimum extent necessary to adequately provide for their own health or safety, or to adequately manage their financial affairs. This was something that came out in 2019, but it definitely holds true. It holds true for the North Dakota legislation, our century codes as well. Okay, so the types of guardian, we have a general guardian, which is a guardian or an agency, and we'll talk about how it could be an agency that has general care and control over a ward's person or estate, and is responsible for both the well-being and financial interests of the ward. There's also limited guardians, which is a guardian that is only responsible in making decisions for the ward in areas not capable of decisions. A lot of those might be financial, or they just might be health, or agreeing to sign contracts. Sometimes you just see limited guardian. I have found out through experience of helping families with guardianship that typically an attorney is pretty weary of a limited guardian, but it is something that most certainly can happen. Temporary guardian is a guardian who is appointed as needs immediate action and is only in place for 90 days and then ends, or the process of general or limited guardian takes place. So mostly you will hear this called emergency guardianship. And that can happen. I don't think it happens widely in North Dakota, but it most certainly can. And just know that it is very limited. Once that is ended, you have to go through the process of regular type of guardianship through that whole process again. So one thing to think about that was that it's going to cost you, because it will go through twice. And some of the ones I've worked on, just depending who your attorney is and what everything needs to be in place, I've had some reach up to $10,000. So that goes back to another reason to think about guardianship early on. If you're working with someone who has disabilities, you're thinking about the services that they get. You know, is there already things in place? You know, can they do many things on their own? And instead of maybe you're thinking they don't need a guardian, but it's always really good to at least look at all the alternatives too, because it might be that they need something else and that they would agree to that. Part of this is to, when we're talking about guardians, I get a lot of questions, well, like what happens to me if something happens to me and I'm a guardian over someone? It's when you're thinking about costs and thinking about, and I know as a parent of a child with a disability, the first thing I always thought of is what's going to happen when I'm not here. So the good thing to think about that is if you have someone else that'll be a co-guardian, it is best to establish that co-guardian while you're establishing guardianship instead of later on. It'll save you cost-wise. It'll also, I believe, save you like sleepless nights because you know that there's someone else in place. A co-guardian could be a relative, doesn't have to be. It could be anybody that you name, but if they go through that process with you, that's already established. Also in guardianship, it's a good idea to leave a line of succession. So somewhere, they may not have to be a co-guardian now, but maybe you have a will, or you have a trust, or you have something that is stating that if the possible case of these two not being able to be guardian, we would like it to go to, hey, you don't, like I said, you don't necessarily have to have that in the guardianship to begin with, but you should be thinking about co-guardians as well. So what is the difference between these? Okay. So temporary, as we just said, it was 90 days. A lot of times, like I said, you're going to see those in emergency situations. You know, I had one where unfortunately it was a car accident, and the guardian that was in the car accident did not survive. And this person needed a guardian right away. So people stepped in. A lot of it was leaving something so that somebody knew what was going on, another family member, but they had to step in and get emergency guardianship right away. I mean, that's just one example of it, but that's probably the one that we see most often. The next one, a partial, like I said, we talked about those partial. When you think about it, like a lot of them talk about, well, we just need somebody to do finances. Okay, so a lot of times I'll give them what a partial guardianship could do, but I also talk to them about power of attorney, because we hear a lot, power of attorney, they're doing like a lot of financial issues. So maybe that's a way to go, and you don't necessarily need guardianship. So the power of attorney would be making the decisions over financial decisions. Some people ask me, is partial just mean like if you have yourself and a co-guardian? No, that's not considered a partial one. It's the partial has to do with what you are making decisions over for a person. A full guardianship is one that has total decision-making responsibilities, so including those medical, housing, services, legal, financial areas. I give some examples there. One thing, if you're going through guardianship, you will find that most attorneys will give the ward the right to vote, no matter what you are you are asking for. I would say that's what you're going to see all the time. Another one you see that a right that might stay is admitting the ward into an institution involuntarily. That's typically written in there that that cannot be done. So they're always, the judge has the final say on what you're asking that you to be guardian over. So some of those things come up, and they might not come up with your attorney. They would definitely come up with the judge. So I'm just going to stop here and see if anybody has questions so far. I don't think we have any. Is that right? Nothing in the chat either. Okay.
At this time, no.
Okay, perfect. Okay. So now I'm going to give you some definitions that you will hear quite often when you're going through the guardianship. One is the petitioner. So that is whoever is seeking the court for the guardianship. The respondent is the person who replies to the petitioner, which is a lot of times like clerk of courts. The ward is the person for whom you are seeking guardianship for. The petition is considered the document that you file with the court. If you have an attorney, your attorney will be filling out that petition and submitting it for you. And there are fees to these things as well. I believe right now it's $80 to petition the court, in case you're doing it on your own. And by the way, just so you know, on your own, you cannot call the Court of Clerks to help you with this. They will not help you with guardianship if you have questions. You have to refer to their website, which will be in this presentation. Let's see, the guardian ad litem is the attorney who represents the best interest of the ward. So when you're having guardianship, I'll use my own as an example. So my son was appointed an attorney on his own. A lot of times, if you're going through an attorney, they will give you a list of guardian ad litems, or they know already of someone who is actively a guardian ad litem currently, one that they can recommend. We kind of have a short list of guardian ad litems across the state that we can give in case someone is doing this on their own, or they're not having any luck with their attorney finding a guardian ad litem. I'll say that happens most in rural North Dakota, but typically your attorney will help you find that guardian ad litem. It may or may not be included with your attorney's fees. Most of the time I see guardian ad litem is an extra cost and they get paid directly. Mostly what I'm hearing is anywhere from $200 to $300. Could be low, excuse me, could be lower, could be higher. There's also something called a visitor, which is a person appointed by the North Dakota District Court to interview the proposed guardian and the proposed ward. The visitor gives a written report to the court, which includes recommendations on the powers to be granted to the proposed guardian. The visitor in person is usually a nursing or a social work, and they have no special interest in guardianship proceedings. So once again, this is something that your attorney can find out who are visitors. Most of the time I do, they're usually social workers that come in. They will have to meet with the ward or the person you're seeking guardianship over. I know some families say, well, why do they have to come in? My son's nonverbal, can't speak, they can't really talk to him, there's nothing they can give him. A visitor will actually typically come in and ask that ward those questions anyway, and then talk to you if you're already a parent. So if you're seeking guardianship for adult guardianship, typically for minor guardianship, the visitor is not talking to that ward, but this is part of the process and it is a required process. Then there's something, the letters of guardianship. So once the guardianship has been finalized, that's the document that the court states what the guardian's powers are and whether they are any specific limitations. So that's where you might see the ward has the right to retain to vote. You might see some of those, or during the hearing, if there were limitations, they would be listed in there. The guardian presents the letters when needed to show for their powers, such when dealing with financial issues or medical providers. A lot of times, so the top paper on letters of guardianship are really what explain it. But you may have to present those if you're switching from maybe pediatric to a regular type of physician. Other things you might have to present them for, like I said, is any financial things that you are taking over. Maybe it's savings accounts, special needs trust, able accounts. It's possible you might have to give them letters of guardianship that they might ask. A lot of times too, if you're talking about someone 17 just going to turn 18 and you're starting this guardianship process, that you might have to let the school know, especially if a child's on an IEP, that there are letters of guardianship in place. But, you know, it's minimal, but you can, of course, always make copies for it. Those are, I think there's one more page here. Okay. The incapacitated person means any adult person who is impaired by reason of mental illness, mental deficiency, physical illness or disability, or chemical dependence due to the extent the person lacks capacity to make or communicate responsible decisions concerning that person's matter of residence, education, medical, and other areas. So these words, incapacitated person, sometimes are found throughout your letters of guardianship. A little note that I've found out over helping folks over the years is that if you are in the process also of applying for SSI, Supplemental Security Income, or SSDI, the disability insurance, typically you would have to have them a copy of guardianship if that is what is happening in your situation. A guardianship is being established. They like to see the words incapacitated person. And it's been a struggle with some. I've had some people call me back and say, well, they're not accepting the letters of guardianship because the word incapacitated is not listed. Typically then, it's just a matter of talking to Social Security and probably talking to the disability services that are located here in Bismarck that determine disability. Not all judges have used the word incapacitated, but hopefully it's explained enough. But again, if you have a lot of issues with that and it's not working, I have referred people to the state's attorney's office. Informed consent means a person's agreement to the proposed course of conduct. Physician's report, that you have to have a physician put in all their medical needs, what their diagnostics may be. Typically, whoever your physician is that you see the most is the person that would do that. Not necessarily all your specialists, unless your specialist is the one that you typically are going to. An interested person is individuals according to the state statute that have a right to notice regarding a guardianship cause of action. So sometimes this may include a parent, a sibling, a spouse, maybe a residential provider, depending on your situation, such as in my case, interested persons. I'm divorced, so an interested person was my ex-husband. So I had to list those in the petition. And then we talk about corporate guardian. That is a corporation that is named as guardian for an individual that may receive compensation in its role as a guardian with the court approval. So we're going to talk about corporate guardians. Does anybody have any questions on some of these definitions or words? Or maybe you've heard a word and you're not really sure what that definition is. Okay, so corporate guardianships. So how do they happen, or why would people seek corporate guardianships? So in this process, the ward has the right to contest its own guardianship. If they don't feel like they want a guardian, they have the right to contest that. That's typically done through their guardian ad litem or in the very beginning. So some choose to say, well, they still need guardianship. They just don't want this person being guardian over them. So you can have what we call a corporate guardianship. Mostly in North Dakota, that is done by Catholic Charities of North Dakota. I have their information listed here. There are a couple other places that do corporate guardianships. In this year and past years, we have always had to seek legislation to get more money into and more resources for these places to, especially Catholic Charities, to do corporate guardianships. People seek them out. Like I said, it may be because the person's contesting it, but it also be because they don't have anybody else that they know could be a guardian, but they know that the needs are there. They have small families. They're worried about filling all the obligations of being a guardian. Some of those then would be thinking about corporate guardianships. There's just a list there of what these agencies can do. Some also can be, under conservatorships as well. Not all of them do that. Some just do healthcare agent as well. But those are some of the services that you can get under corporate guardianship. This past legislation, there was some new guardianship funds. A few years back, there was guardianship establishment funds created for families who were seeking guardianship. We'll talk about that one a little later too, but that one, for the original guardianship establishment funds, the person could not be under developmental disability services. In other words, they could not have a disability case manager. So it was for people seeking that who were at 100% of federal poverty level, which means really low. I mean, you really didn't have much money, and that's 100% of poverty level for the ward. Okay. So that was established. But what we're finding out is more are having issues, or the barrier to that was that a lot of folks had DD case management. So we established some new funds, or our legislation did. And it is for those who have developmental disability management. They don't have the financial resources to complete that legal process. So what has passed was up to 100 eligible adults who fit the criteria could get some funding, and they would give each of those about or give them the maximum amount of $3,000. So $3,000 is just slightly above the average of what it costs, the average now cost for guardianship. But I put some websites here about those. Typically the recommendation goes from the DD case management, which is different from other things. Sometimes the DD case managements are not doing this, but this is going through them. I do believe I have worked with 2 so far. This started August 15th of 2023. And I don't know how many more have gone through. I think the last I heard it was 3 or 4. 2 I've worked on pretty personal. I didn't feel like there was working with the people that were trying to get this established and the program managers. I didn't really think there was much more paperwork than you would need for filling out for any type of application for service. I thought it went through very fast. The attorney that accepted those $3,000 seemed to be, yep, the $3,000 will cover what I do. So there wasn't any extra cost for that. So I thought it went by pretty smooth, and this is a big step for North Dakota, and hopefully in the future we can get more than 100. But that was the fiscal note on it this time around, but maybe in 2 years we can get more. So it's always important to pay attention to legislation if it's something that you're concerned with, such as guardianship. So any questions on that or anything so far?
Yes, there are a few questions.
Okay.
The first one is there a payee included in this, or can there just be a payee appointed?
So if you're talking about a representative payee, I will talk about those. That would be an alternative to guardianship, or are you talking about a payee with these funds? If they could answer that.
Clara, do you want to specify your first question?
So if we're talking about these funds, that money goes directly to an attorney. It does not change hands with anybody else. A rep payee, typically you see under, if the person is collecting Social Security, there may be a rep payee to take care of that, and that is an alternative to guardianship. So I don't know if that answers.
She had said with their personal funds.
Okay, I might not be understanding the question.
SSI.
SSI. Okay. Yep. So if you're doing stuff with SSI, and there's no, even if guardianship is established with SSI, if you need to have the decision-making process of SSI, you would, when you apply for SSI, you would do the application to be a rep payee. Now, some folks, they don't need guardianship. They don't really want power of attorney or anything else. So that actually is a very least restrictive for a person just to have a rep payee. And so they would have say-so over just that SSI or SSDI account. Does that help? If you're looking for more of the money not just the money that a person would receive or the benefit a person would receive from Social Security. Like if they have other funds, you would probably need more than just a rep payee. You might want to at least consider power of attorney.
Okay. Next question. It's kind of a long one.
Okay.
I don't know if you can answer this. I have a couple as clients who have had their children taken away, even though they had not been charged with anything. They do not have an arrest record at all. The kids wound up with his mom, who wanted them to start with. They have a court-appointed attorney, and this has been ongoing for several years. I asked who the guardian ad litem was, and there was not one. How can the parent contact the court to ask for one? The two girls are elementary school age. Mom had another baby a year ago. The social worker was outside the hospital and they took the baby from her and gave her visitation. Now she has the baby back, but does not have her other girls and has been fighting for them since day one. I cannot understand why the kids were taken when I know other ones who the parents were found guilty of meth, other drugs. One is living with a sex offender of little girls, and they all got their children back. One of the girls has autism and screams like crazy when mom has to leave.
Okay, so this is really complicated and very legal, and I'm not an attorney, so I can only answer this by giving you resources of maybe somebody to contact. So if the children were taken away, okay, and you just through your own investigation, you cannot find that there was a guardian, or if there was an attorney, or if there was a court paper. So the reason that they were taken away, I mean, if there's no court document on this, then they were taken away not by legal issues. So like you would want maybe social services in that area may have some information. But you, of course, if you're working with a client, would have to get some type of release so that you could be given those court papers. If mom is incapable of doing that herself, you would contact the court in that county. So in this situation, a clerk of courts may be able to help you, because if they were taken away without any legal documentation, I don't know whether that's how that happens, but you know, was it, you said there's no arrest warrant, so was CPS involved? Was, you know, any police, any sheriffs, anything involved? Those are the places that I would start. But if they were taken away by some type of legal situation, which there can be plenty of them, though I'm not sure why she would have never been informed of that, then you should probably talk to the clerk of courts in the county where they live or where the children were removed from the mother. The other thing to check, you kind of said they went, I'm trying to remember, did you say if they said they went to a grandmother? You know, does she have some legal right over these children? And that would be to look, you know, was there emergency guardianship that was filed? So a grandmother might have got them at least for 90 days, but you said this has been going on for years. So there should be some type of legal, maybe a power of attorney was in place. But those would take a lot of investigations, and I can't answer how you get them back because that would be legal. Now, at the end of this PowerPoint, you have my contact information. I'd be more than happy to try to talk this through with you, but again, I can't answer any legal questions. So I don't know if that was much help. I feel like this is a very complicated situation. And it's just kind of diving down into how this all happened.
Her follow-up question to that was how she can get a guardian ad litem.
Well, a guardian ad litem would represent the children. So a guardian ad litem would not be able to necessarily help with getting those children back into a mother's home, if that's what, is you're talking about. An attorney might, but if they were taken away through any type of guardianship at all, whether it was even emergency guardianship, those children would have already been represented by a legal person and possibly a guardian ad litem. But an attorney would need to be set up for the mother if she is seeking to get her children back.
That is it for now.
Yeah, a guardian ad litem in this case would not be representing the children until the mother sought out legal. And then a guardian ad litem could be appointed by the court. Or if you're looking one in a specific area, you can give me a call and I can try to give you a list of those too. Okay. Does that, I hope that helps a little. But most certainly I'm willing to talk to you as well. And you said that was it?
Yep.
Okay. So here are some questions when you're working with people to think about how you want to think about guardianship. So I do a lot of this. I have a training called Caregiver Cafe. And so we talk about all these things very early on because it is something that you really need to think about early on and continue thinking and being with that person as they change through the years of what type of guardianship or an alternative to guardianship that might be needed. So one of the first things I always talk about with parents or providers is, what do you want your child's future to look like? As they go through the years, sometimes you're thinking when they're young, oh, they're going to need me the whole time. They're not going to be able to do anything on their own. But as time goes on, or they're accessing more services, or really just they change, just like everyone else, we all change, that may be able to access a lot of things on their own, make their own decisions, or do an alternative. So it's always important to think about what the future may look like. Now, of course, in these, I'm talking about persons who are minors that are going, that the process of adult guardianship is happening. When we're talking about minor guardianship, there's usually a whole bunch of different reasons of why there's a minor guardianship compared to adult if you're seeking a minor. If you're talking with clients, one thing you don't want to do, and I've had this happen a couple of times, is if you're a parent or a client is seeking guardianship for someone who's 17, who's going to be turning 18. So we typically tell people to start like thinking about this or looking at these things 6 months prior to the age of turning 18. But of course, you can seek it at any time. But you don't want to get that guardianship in place before they turn the age of 18. Otherwise, you will have to go through the process again and seek that guardianship out for an adult because they have turned to adult. I've only done that twice, but unfortunately that can be a large cost as well. Typically attorneys, they're going to be doing this so that the guardianship is signed through the hearing after they turn the age of 18. But like I said, it's happened twice and for unfortunate reasons. So it's another good thing to speak about your child about guardianship or the alternatives, especially as they're getting older. If you're also speaking to family members that you may have like a co-guardian, like for me, it was my son who's 10 years older than Aaron, who needs the guardianship. But I talked to him a lot about, is this what you want to do? Are you prepared to do this? What if something happens and, you're co-guardian, but all of a sudden you decide you can't do this, those types of things come up. And also for him, he got married. So, it's talking to his wife, is this something that you want to do, and explaining to them, and having them work through what the guardianship process is or the alternatives as well. So what are the alternatives to guardianship? So those are things we're going to be talking about coming up here. So you will see those. Always want to talk about alternatives. Also, again, is the cost. So guardianships through an attorney are going to cost. If you do them yourself, they're going to cost because there are filing fees that you must pay. So it's another reason to start thinking early on to save up for guardianship. Like I said, the average in North Dakota is around $2,500 to $3,000. I've had some families as low as $1,200 to cost for guardianship with an attorney and a guardian ad litem and the visitor all being paid. And I've had some go up as high as $10,000. So it really depends on what attorney you're seeking. Most attorneys can do guardianship if part of their practice of services is state law, family law. To find those, we try to keep a list of around North Dakota who have done a lot of guardianships. Maybe you have a family attorney that will doing that. Or maybe you're working with a client. For me, it's mostly because I'm working with those from minors to adults. So I'm working with them early on. And I've helped them open ABLE accounts for them. You can actually, a person can pay for their own guardianship out of an ABLE account, which is where my son paid for his. So just to know that you want to talk about the resources and costs. And make a list, of what the strengths and weaknesses of your child in managing that life situation are. So kind of go through the subjects like finances, what can they do? So when I was looking at my own son and his finances, he has a special needs trust, which he would never know anything how to do with. He has an ABLE account, and what he does know is that he can buy things with his debit card that are disability related expenses. So if he needs to go buy a pair of jeans, he'll put in his card and, buy a jeans, but he could never manage his own money, so the strength and weaknesses, he currently does not really even understand his diagnostics due to the fact that he has, an intellectual disability. So you want to think of what are the strengths and weaknesses when you're deciding whether you want to do guardianship, or maybe we're thinking about an alternative. If guardianship is sought out, but my child doesn't want a guardian. So I run into this quite a bit, where the minor knows that guardianship is being sought out for him and is extremely upset about the fact that they may have somebody else making their decisions. So this is really going to play into that guardian ad litem. Because a guardian ad litem then will be appointed. I mean, it's already appointed, but that is their job, is to seek out why that child does not want to have a guardian. Most likely they will be attending that court hearing to speak to the judge of why this person doesn't feel like they need a guardian. So that's something you want to think about early on. That might be a decision of why you might seek a corporate guardianship as well. Because sometimes they just don't want family members being a guardian, but they're okay with somebody else helping them. So it might be corporate or it might be an alternative. Because any person can contest their own guardianship. Okay, so these next slides are going to kind of show you what I talked about, most restrictive to least restrictive. So a judge is always going to look at the least restrictive, just like I'm sure you've heard. I mean, in school, they're looking at least restrictive. In home and community-based services, they're looking at less restrictive. So this is just kind of a graph that talks about it. So, I mean, we're talking at the very peak there. Guardianship, full guardianship is very restrictive. These are just things that people use as alternatives. I don't go into all of them, but you can see how they start getting less restrictive. So when we're talking about monies, so a special needs trust, you see trusts up there, that is much more restrictive than an ABLE account. So we're kind of going through the lists here. And one of the biggest things that you'll see at the bottom of the page is supported decision making, which we'll be talking about. And I think this was just another slide for it. So if you're thinking of alternatives, these are ones that we see, quite often as alternatives. So someone had a question of representative payee. So a representative payee is a person or an organization, and they appoint a payee to receive the Social Security or SSI. I should put SSDI benefits in there as well, for anyone who can't manage or direct the management of his or her health benefits. Okay. A representative payee must spend the disability benefits appropriately or help spend appropriately for the disabled person's need, must properly account for the money spent, must report certain changes in life or life situations of the disabled person, the beneficiary, all report to Social Security Administration. If you work with Social Security, you know that they can audit anybody or do a review at any time without a lot of notice. So all those things have to be in place. So there is responsibility on a representative payee. If someone is signing up for Social Security benefits, you do the application for representative payee at that time. I do have families call me and they say, oh, my child gets SSI and I'm the representative payee for that, but now I've retired. So now they're going to move to disability insurance. Am I still the representative payee? You can be. You just have to make sure that each time you move for something, you're doing the application for a representative payee at that time. Another thing you want to be aware of, if you are a representative for a pay, making sure that at the banking institution that you are using this, where that at Social Security account may be set up, you have to make sure that the bank knows that you're the representative payee, so that it is looking, there's certain codes that banks have on there to make sure that it's a representative payee account. Okay, because if you go through a review with SSI and that account is not set up correctly, a couple things they can do. They can give you opportunity time to fix that, or they can make you start paying back. It cannot be an account that you have jointly with the person who is receiving SSI or SSDI. It has to be set up as a rep payee. Representative payees cannot collect a fee for their service if they're the beneficiary. And you may be able to collect a guardian fee, though, if the court has authorized it. So, questions on rep payee?
There was just one comment. Representative payee should keep track of what they pay, as Social Security will send a request of how are you spending their money.
Correct. Like I said, they can review you at any time. And in North Dakota, it seems like as soon as you become a rep payee, they review you. So yeah, keeping track. When a person is on SSI or Social Security benefits, there's a lot of accounting work that has to be done. So you have to keep track of anything, you keep track of their receipts, what they're using SSI benefits for, because, SSI is given for the fact that they need this money to live. So typically you're using SSI benefits for clothing, food, shelter, those types of things. So if you buy something with a Social Security benefit like SSI, let's say it's a computer, but you already have other resources, that computer may count as a resource with them, and then you could be losing your SSI or at least suspended due to those things. And SSI is something that has to be spent down as well. So a representative payee has to keep track of how much is in that account and how much can be in that account, as you can only have a certain amount, which is the $2,000 for a single. And so spending that money down and keeping that track of all that is extremely important. and so, you know, it's more work than like if you're just working with an ABLE account, because usually that is done on the ABLE account itself. You can upload receipts and everything, but with this Social Security money, it's extremely important because you could end up paying back money if it is being used improperly. Okay. So next, we're going to talk about what's supported decision making. This is probably, especially in North Dakota, is a newer alternative to guardianship. So supported decision making is a tool where a person with a disability can be empowered and supported in the process of making their own decisions to whatever extent possible as an alternative to guardianship. So I was part of the lobbyist group that worked on getting supported decision making in the state of North Dakota. So on March 19th in 2019, Governor Burgum signed House Bill 1378 and it became law. North Dakota became the 7th state to sign such a bill. And a lot of people worked on this bill, but really kind of the basics of what supported decision making is it's a written agreement that formalizes a supported decision maker and to be recognized as so. So when this became more widespread across the United States and most certainly here in North Dakota, it was a paradigm shift to express their own self-determination. Under guardianship, changes have to go through a court system to become effective. Under supported decision-making, a change can be made to the agreement at any time without a court process. The court system under law must recognize supported decision-making as an alternative to guardianship. So our judges in this state recognize supported decision-making as an alternative. The American Bar Association has been long committed to advocating for the least restrictive alternative to guardianship. If you remember back on those pictures, supported decision-making is probably the least restrictive. So what are roles in that? So the first thing to remember in supported decision-making is that person is the decision maker, okay? The person who wants supported decision making to be the least restrictive is the decision maker. No one else makes those decisions for you, okay? The decision maker chooses whom he or she would like to have help in making decisions, but the decision maker at the end is the one who decides. And so then also the decision maker chooses the way they want to have decision makers help them. They're called supporters. And supporters can be anybody, friends, family members, providers, or anyone who agrees to be in that role. So I am a supporter in about 5 persons who have supported decision making as an alternative to guardianship, and I'm listed in their agreement. So supported decision-making agreement is the written plan developed by the decision maker and his or her team that gives information about who the supports will be, or what the supports will be, what kind of decisions will be supported, and what kind of support is requested. So here are some of the examples of what may be in a supported decision-making agreement. So learning to manage money. So let's say someone has chosen this to be their alternative to guardianship, or has just chose to implement a supported decision-making agreement. They might get advice on how to set up money management, maybe on an app, on a phone. So they have easier access. I mean, we do everything by our phones nowadays. And so maybe they need help with managing that portion of it. They also may come to you and say, you know, hey, I'm gonna buy this car, but I'm not real savvy on agreements that I might have to be signed. Would you come with me? Okay, certainly that would be helping them manage money. you know, maybe this person has in there that they would give advice on things that they're not, that they feel they don't have enough knowledge on, which might be buying a car. So it would be like, if someone asked me that, like, this wasn't a situation that I did, and that's what they did. They wanted to buy a car, but they were going to buy a car that was going to cost them a lot of money at the end of the day. So we found another car. So I didn't give them decision to say, don't buy that car. We laid out in front of them what this car was going to cost them and said, are you sure that this is what you want to do? And they realized then that, no, that's not what they wanted to do. And they asked, the person asked us to help them find a vehicle that was appropriate for them. Okay. So those are the things. Again, you are not making the decisions for them. It could be in health to support, to come to medical appointments to help understand procedures. That happens quite often. A lot of times I will do that if one of the persons I'm in their agreement, if a surgery is coming up, they will ask me to come and help support. So I do that. Again, I'm not giving them the decision whether they should have that surgery or not. I'm just there to support them. Housing, explaining language on a lease. We do that also. You see a lot in supported decision making. So if you're looking at the North Dakota Protection and Advocacy site, has on their site, they have documents and templates for supported decision making. These are ones that have gone to the Bar Association in North Dakota, and that judges have seen throughout the state of North Dakota. So I highly recommend, if supported decision making is a choice, that you use one of these templates. There might be minor things that you change, but again, this is a paradigm shift. I think, but I think, you know, the shift is that before we didn't have as many alternatives. So guardianship was just like, it was just something that you automatically do. Now we have many more alternatives, and so it's something to, you know, really consider. Questions on supported decision making? Okay, so another difference is, you know, some people ask, well, if I'm a guardian, do I need a power of attorney? More than likely not. But if I'm a power of attorney, do I need a guardianship? More than likely not. It just depends on the situation. And so a power of attorney can name an agent to handle the affairs before anything happens. Okay, so the word before is important. A power of attorney is a legal form, but not a court form. A power of attorney will cost less and take less time, but not all institutions may honor a power of attorney, and allows for more ability to make choices depending on the document. So we hear a lot of those power of attorney, right? If someone passes away in your family and there's a will, the power of attorney may, you know, is the person who sets forth that will. But a power of attorney could also be used, like I said, for an alternative guardianship, because maybe it's just finances. Most power of attorney is around the finances, so maybe you can make all the decisions, but you have a special needs trust, and you have no trustee on that. You're not sure how all that works. A power of attorney may have the legal right over that special needs trust. We see that often. So again, a power of attorney is an alternative. Okay, it's going to cost you less. You want to make sure that whoever the person is, that anything that they're accessing, that a power of attorney, that institution will honor. Some of those we see in healthcare directives that we have seen in certain areas in North Dakota, that they don't want to accept power of attorney because it may not be worded right. So those are things that you must think about. And again, it's for limited, very limited, what a power of attorney may do as an alternative to guardianship. So a guardianship is only obtained after someone has become incapacitated. Okay. So you can't say, oh, I'm going to seek guardianship because I think in 2 years they're not going to be able to do anything. You cannot seek guardianship that way. But maybe then that is why you might seek a power of attorney at that time. Guardianship is a legal form and a court form. It usually costs more and takes longer to set up. Of course, it's set up by the court system, so they will honor that, what has been declared. And of course, there usually is less choices. So any questions on power of attorney?
There are a couple questions.
Okay.
What if we have a client who seems to need supportive decision-making? To whom do we refer them to get this process going? I'm thinking a Center for Independent Living.
Yep, absolutely. Center for Independent Living is a perfect resource for that. Federation of Families has a person that helps out with supported decision making in North Dakota. They can also call Family Voices of North Dakota. Protection and Advocacy is another place that you might start. Like I said, they have the forms, but they have people that make those things to begin starting. Sometimes a case manager can help if there's a case manager involved, just depending on their skills in that area. But that's how you would get started, and most certainly talking to the person who is seeking that supported decision making. Like if you're helping that client, go through that list. Okay, like where do you think you would need support? Okay. And really lay those out into one of those forms in a template and go through there. Now, they don't necessarily have to be, like I said, presented to the court. There's something that in place. But let's say something happens, the court will recognize that as an alternative to guardianship. So we've seen in a couple of cases, like a medical appointment, they felt that person who had asked to have support in there really was not granted that. It's rare, very rare, that any entity would not accept what supported decision making is. And that's why it's the least restrictive and the less costly, because it really doesn't cost anything to set up. But like I think Freedom Resources in the Fargo area has done some, if I remember right. So. And of course, if they have family too, it might be something to talk about with them. The ones that I work on, there's no family members involved. And again, a supported decision-making agreement can be changed really quickly if you want something changed. Whether you want, this person not to support you anymore, or you found someone new. I mean, we always say that you should have more than one person be in that agreement with you, because one, right, there's no other choice. It's kind of like beneficial, other things you set up. You want to have an odd number, but not one. And then knowing that who this person is, trying to figure out who is in their life that they would want to help support that area, and make sure that you're talking to them too. Any other questions in there?
No more at this time.
Okay. Okay. So we're going to quickly go through the process. So process, like I said, to seek out guardianship, we usually give 6 months in advance is what I tell people when they're asking me. But of course, you can seek out guardianship at any time. People say, well, they're already 18. Can I do guardianship? Absolutely. The only thing is, remember, from minor to adult guardianship, if you're only trying to seek one, just do it when they're turning 18. So again, we recommend that you retain an attorney, but you don't necessarily have to. You can do it by yourself. Just know it is a cost and a lot of legal language involved. They collect and process the information on the proposed petitioner and the proposed ward. So after you meet with the attorney, he'll write all those petitions up and he will file them. Typically at that point then is where they name the guardian ad litem, the visitor, and who the expert examiner is. Those would typically be the medical person. They prepare that of the guardian and the confidentiality forms you may have to pay or sign for. They prepare those orders for all the 3 individuals who are heard at a hearing. They file that petition and then you receive a hearing date. Like I said, most people, I do get a lot of questions and okay, well, our hearing date is after they turn 18. Are we in trouble? Do we need to get a power of attorney before that? Not if you're the parent. I mean, you're still, people say, well, what happens if they're in a car accident or something like that? Well, you are the next of kin, so medical would be looked at then. So don't worry if the hearing date is after they turn 18, because really it needs to be. Some happen right on that day, but others are typically a week or 2 after they turn 18. After the hearing, you get statement rights, you're served the notice, then they file all the affidavit. And this should have been up at the top, but when you're seeking out guardianship, you must complete guardianship training and present that certificate to your attorney. So that is done online. It is not graded. People ask me, what happens if I fail? That doesn't mean you cannot be guardian, okay? This training goes through the processes of guardianship training, and then there's little quizzes afterwards that you take to see how much you know. It's nice. You can always refer back to this training. When you're done, you'll receive a certificate and your attorney will collect that and present it to the court. If you have co-guardians, they must complete the training as well. Other things I get, well, I'm divorced, and sometimes for an ex-husband or ex-wife, whatever the situation may be, there might also be an affidavit that has to be signed, whether they're seeking or contesting guardianship that you're actually looking after. So in my case, I was divorced, but he signed, he was not seeking anything else. He had to sign that affidavit. And then basically you're attending the hearing, but this can take months over time, because like I said, a guardian ad litem will come visit you, the visitor comes to your home or wherever you may be at. And then of course your medical records have to go in as well. Okay. Here is the information on the guardianship training. There's the website also on this website. If you're it'll give you all the forms. The forms are there, especially like I said, if you are doing the self without an attorney. Otherwise, typically your attorney has all the forms. And so after the hearing date, after the guardianship is established, there are some forms that you have to fill out. One of them that you have to do right away is called the beginning inventory. And that's really taking an inventory of what the ward's possessions are. So financial, there's questions on, you know, banking institutions, how many times you're seeing doctors, those types of questions, which is why it's extremely important to keep good information, because that also an annual report. Those you have to do again once annually. They'll typically send you something in the mail. We have a lot of problems with mail across North Dakota, so some have missed out on that, but just make sure if that annual date is coming up that you've gotten your report. Otherwise, call the clerk of courts in the county where the guardianship took place and they will send them to you. If you have co-guardians, they must be part of that annual report. They have to sign and date it. Now, my son's is out of state, but again, he has to have signed a date and he has to have a notary republic put their stamp on those. Every 5 years in North Dakota, there is a 5-year review of guardianship. Okay, this was a central law that came. It's been in place for a little while now. So every 5 years, a judge will review the guardianship. So at this time, interested parties need to be notified as well. The 5-year really is a basic review of guardianship. If a judge feels there needs to be changes, he will make those changes throughout the hearing, or otherwise you just may retain guardianship. So it's really like doing a check on it. Now, there is an issue if any of your clients have ABLE accounts as well. Sometimes if you are a guardian over someone who has an ABLE account, some of the states that offer ABLE accounts don't like our wording of review of guardianship because judges in the state use the word terminate, okay, or expired. But actually it's neither one of those, it's a review. As advocates, we went to the state and judges and bar association to see if they would change it, and they felt they did not need to change that. So instead we went to ABLE counts of different states and federally through the Family Voices National. Now states are starting to accept that language that we have. One state that is still having an issue with it, if you have folks who have ABLE accounts, would be Minnesota. So this is the other establishment fund program that is going on. So this is for someone, if the ward, they have an income limit of 100% of federal poverty level, there are some funds that could be available if someone could not afford guardianship. And again, there's a website there for self-help. This I kind of went over, was the 5-year review. Those are the things that can happen. You continue with the current guardian, or there's different guardians applied, or they terminate the guardianship. Okay. So guardianship transferred to another state. I do get this question quite a bit for transferring jurisdiction. So the last one I did, there was a guardian, they passed away, and the co-guardian lived in another state. Just to know that the process of, you do have to go through the process of the jurisdiction in the state where that person is going. But you also have to do a process here in the state of North Dakota. So you have to petition the court to transfer that guardianship or conservatorship to another state court. And then you have to work with the other state to get an order of accepting that transfer as well to their state. If they move to the other state, then all their codes and laws for guardianship are in place there. So they may have other things, like North Dakota has a 5-year review. Some states do not have that. So you have to follow all of their rules. Other people have asked me, do you need an attorney for this? Not necessarily, but I would check with the state that they're transferring it to. So like this one was to the state of Washington. And in Washington, they have liaisons that help you with that at no cost. Okay, so checking out those things. Some miscellaneous says you file a report when needed if the ward passes away. There's papers for that. You can always find them on the North Dakota Courts website. If they're selling any property, that needs to be noted, like in an annual report to the 5-year report. Appointing a successor guardianship. Like I said, you may have a co-guardian, but maybe that has changed, or you're doing another guardianship. Just make sure that, you know, the courts are knowing that, and the process that goes through that, which is also on the website. There's forms that you fill out for that, or request of termination, like you are requesting to terminate your guardianship, or the ward is requesting it. The ward itself can request termination. So some tips that, like I said, like start for minors moving into the adult world, start guardianship 4 to 6 months ahead of time is what we ask, because I do say shop around for attorneys if you don't have one that you know, or if you're doing corporate guardianship, to make sure that you're contacting them so they know something is coming through. Think about whether, you know, you want to appoint that co-guardian. That's important. Like I said, you'll save a lot of money if you do that along with yourself if you're going to be guardian, and then keep really good records in health of the ward, just like you would for any other services, like someone mentioned for Social Security. You really got to keep a lot of paperwork. So that is the end of my presentation. This is my contact number, so you can contact me at any time. I do help providers with individual cases. So mine is on the top. Our Family Voices, our director is located in Edgeley. You can also go through her. I am not an attorney, so like some of that question might more be for an attorney. So I can't answer those, but I can try to direct you to the resources that you need, offer the lived experience that I've gone through, and then being helping other families with guardianship and also alternatives. So more than happy to do that.
All right. Just one question. Can we receive a copy of today's PowerPoint presentation?
Yes, so did you get the email? I emailed it to Cheryl and them yesterday. If not, I will, or Kylie, I will email it again to them, and you can send out to whoever you need to. Will that work?
That works great.
Yes, you can have a copy.
Are there any last questions for Vicky? I just want to thank you, Vicky, for taking time out of your schedule to present to our group. It was great information. And again, just a reminder for those that are still on, if you need a certificate of completion, please email Stacey and she will get that certificate sent out to you. Also, at the end, it might be coming tomorrow. The survey will be coming tomorrow for you to respond. So just take a couple minutes to do that, please. Any feedback and future topics are greatly appreciated for the next round of training topics. So thanks again, Vicky, for this great presentation and information, and hope everybody has a good rest of the day. And we will get that PowerPoint sent out to everybody.
Yep, and if you ever need anything on ABLE accounts as well, I do a lot of presentation on ABLE accounts as well, so.
All right, thank you.
Thank you, and thank you. Bye-bye.